That is perfect. Please restart the clock. Thank you. Some is recognized.
Some may disagree with that. I want to thank the gentleman from North Carolina for giving me his microphone. Mr. Jarvis, in October of 2011, Occupy protesters descended upon McPherson Square and they decided to stay. Despite the clear language of the law, these protesters camped at McPherson Square with the definition of camping being sleeping or preparing to sleep for 100 days. They camped in violation of the law, and you did not make a single solitary arrest for camping. So Congress decided to have a hearing and ask you why you were not enforcing the law. And you told us, Mr. Jarvis, that you had a great deal of discretion in how and when to enforce the law. You told us that you were, after 100 days of not enforcing the plain language of the statute, working with protesters to, quote, gain compliance, whatever the hell that means, with the law, and what you called, quote, a measured and reasoned approach. By the way, Mr. Jarvis, those were your words, not mine. So the law says no camping, but the protesters camped anyway, and you didn't do anything in terms of arrest or citations for over 100 days. So, Mr. Jarvis, I want you to fast forward 2 years. Parks are closing. Access to monuments is restricted, even access for those who helped build the monument in the first place. You didn't wait 100 days to enforce the law, Mr. Jarvis, with veterans who wanted to see their monument. You didn't work to gain compliance. Veterans weren't greeted with a measured and reasoned response, Mr. Jarvis. They were greeted with barricades on the very first day. Furthermore, they could not exercise their First Amendment rights to walk to a monument that they helped build, but yet some of our colleagues were allowed to exercise their First Amendment right to protest whatever it was they were protesting on the National Mall. So I'm going to read something to you, Mr. Jarvis. And I want you to ask me if you recognize who said this. Because of the lapse in funding, you are having to deliver difficult news to our visitors and partners. The functions we must perform under a shutdown are not the reasons any of us join the National Park Service, but they are the duties we are required to perform by law and regulation. Do you know who said that, Mr. Jarvis?
I believe I said that.
You're right, you did. So can you tell me why you would not enforce the law at McPherson Square, but yet you greeted veterans with barricades on the very first day? What regulation can you cite to me that required you by law to erect barricades?
The contingency plan that was approved on September 27th for the National Park System is in compliance with the Anti-Deficiency Act.
I'm looking for a statute, Mr. Jarvis. I am looking for a citation to the Code of Federal Regulation or the U.S. Code for why you erected barricades. We've established you did not enforce the law for 100 days for protesters. Agreed? You agree with me? You did not issue a single citation for camping, right?
I believe that is correct.
Either it is or it isn't. Is it? Not one single citation for camping.
I do not remember exactly.
Well, your previous testimony was that you had not issued a single citation for camping despite 100 days of noncompliance.
That was 2 years ago.
Okay, well, I can cite you the regulation that you did not follow 2 years ago. Can you cite me the regulation that required you to erect barricades to prevent veterans from accessing a monument that they built?
I can cite the Anti-Deficiency Act.
Can you cite a regulation that required you to erect barricades? Mr. Jarvis, that is not a complex question.
The Anti-Deficiency Act requires that I reduce all employees down to only those that are necessary for life and property. That required the closure of all 401 national parks.
Mr. Jarvis, why did you fail to enforce the plain language of a statute for 100 days for protesters? And yet, on the very first day, you denied access to a monument that veterans helped build.
On the very first day of the closure, I implemented a closure order for all 401 national parks in compliance with the Anti-Deficiency Act. And immediately, immediately that day also included as a part of that order that First Amendment activities would be permitted on the National Mall.
Do you consider it First Amendment activity to walk to a monument that you helped build? Or is it only just smoking pot at McPherson Square?
The First Amendment activities, we are content neutral on First Amendment on the National Mall.
That wasn't my question. Do you consider it to be an exercise of your First Amendment right to a walk to a monument that you helped build?
If an individual declares they are there for to exercise their First Amendment
who were they to declare it to?
The gentleman's time has
Barricade?
expired.
Could I ask the final question? Who were they to declare it to?
To
A
the
barricade?
ranger on the site. On the National Mall, any group under 25 does not need a permit to exercise their First Amendment. And we set up the policy to allow our veterans in, including all of the honor flights under First Amendment.
Gentleman from Texas yields back. Chair will now recognize himself for questioning. Professor Tiefer, would you seat a juror who referred to your client as an obscene body part?
I'm sorry.
Would you seat a juror in a trial who referred to your client as an obscene body part?
I really have trouble giving you an answer, except that sounds
Well,
like
then
bad.
you would starve to death as a lawyer if you can't answer that question, Professor. You would seriously consider seating a juror in a trial, a criminal trial where your client was accused of a crime. If that juror had referred to your client as an obscene body part, you would struggle with whether or not to strike that juror?
Well, it doesn't sound too good.
No, it's not. And I'll give you some free litigation advice. You'll want to use one of your strikes on that juror. How about if you were a prosecutor and one of the potential jurors referred to the police as terrorists who are going to bring the country down? Would you seat that juror in a criminal prosecution if you were the prosecutor?
I wish I saw the connection here, but that's
I'll give you the connection. Lois Lerner just referred to conservatives as an obscene body part, and she said we were crazies and likened us to terrorists.
Well, Mr. Chairman, if
You are not recognized. The gentleman from Georgia is not recognized.
well, would the gentleman yield?
No, sir, I will not. Let's go to the regulation, Professor. Conflict of interest for the department. People like standards. They like bright lines. So I thought it'd be interesting to go find out what the Attorney General's standard is for recusal. And you know when he recuses himself? I'll quote him. When there's the potential appearance of a conflict, he recused himself from a criminal prosecution when there's the potential appearance of a conflict. Those are his words, not mine. So that's the standard for when there should be a conflict. I want us to analyze whether or not there could possibly be the potential appearance of a conflict. You have the President of the United States. When I ask a question, it'll be very clear, Professor. The President of the United States, in the most widely viewed television show in our country, said there's not a smidgen of corruption. You don't think that is the potential appearance of a conflict?
for the issue of a special counsel, which is what I'm here for, I think.
How about give me a yes or a no, and then you can explain your answer.
I think it's irrelevant what the president says to whether there's a conflict of interest.
What if a judge says, let's go give this guilty bastard a trial? Is that irrelevant? Would you want that judge? If he prejudged the outcome of a prosecution, said, let's go give this guilty guy a fair trial.
Given the independence of the public integrity section for the last 30 years, I don't think it matters what.
So you don't think it matters that the chief law enforcement officer for this country, before there is an investigation, while there are emails missing, before he's analyzed one scintilla of evidence, prejudges and says there's not a scintilla of corruption? You don't think that matters? You don't even think it creates the potential appearance of a conflict?
I absolutely reject that the standard here is the standard you're naming for recusal. If he recuses himself, it's still the same justice.
How about when the Department of Justice trades emails with Lois Lerner seeking to implement an idea from a Democrat senator? Do you know Senator Whitehouse?
My understanding is the idea was rejected after the meeting in question, that the idea was...
I'm simply saying, do you really want the Department of Justice and the IRS taking their prosecutorial advice from a Democrat senator? I thought the Department of Justice was blindfolded.
I'm glad they rejected the idea.
I'm sad that they even discussed it. I'm sad that they even discussed pursuing, because when the AG sits where Professor Rotunda is, all we hear about is how he doesn't have the resources to actually do his job. And now they're going to contemplate manufacturing false statement cases?
The standard
So
is not a
you do not think
potential
there's even the
appearance.
potential appearance of a conflict?
That's not the standard. You're talking about recusal, which is whether it's the AG or the deputy AG who deals with the matter. That's recusal.
All right,
This
just
is
so the
special
record's clear,
counsel,
you
which
don't
is whether
think there's even a potential appearance of a conflict? We're not even going to get into Ms. Bosman. How about extraordinary circumstances? Do you think it is extraordinary when a government agency targets people based on their political ideology? Do you think that that is extraordinary?
I think it's an issue of what the Department of Justice, not the IRS. The IRS is much criticized, and I assume rightly so, but the Department of Justice under the special counsel regulation is the one we're talking about.
Well, I'll tell you what, let's go to the third element. How about whether it would be in the public interest to do so? Would you agree to let our fellow citizens decide whether or not they think a special prosecutor is warranted in this case? That's the third element. And by the way, the Attorney General drafted this regulation, this CFR, so I assume he put in there it would be in the public interest to do so. Would you agree to let our fellow citizens decide whether or not there should be a special prosecutor?
You mean by poll?
However,
No,
we
I don't
elect
think polls should tell
presidents
the
that
Department
way.
of Justice what laws to enforce.
So you
No.
see no potential conflict of interest. You don't think this is an extraordinary fact pattern, and you don't trust your fellow citizens to make the call.
It's not a matter of trusting. You can't run a Department of Justice and decide extraordinary questions of the law by poll numbers. No, I would not
Neither
like to
can
do
you
that.
prejudge the outcome of an investigation that hasn't even started. You can't do that when you are the chief law enforcement officer for this country, and it wasn't a hot mic situation where he's whispering to Eric Holder. It's on the most watched television show in our culture. And he prejudges an investigation, and you want us to expect that the outcome of this is going to have any validity or credibility. It's not going to happen. And
Mr.
with that,
Chairman.
I would recognize the gentleman from Idaho.